I have presided over hundreds of trials across more than 2 decades on the bench, but there is one case that still returns to me in quiet moments long after the courthouse lights have gone dark. I have sentenced criminals, dismissed false claims, and watched families break apart under the weight of truth. Yet nothing prepared me for the day a woman stood in open court, looked directly at us, and declared that the entire justice system was corrupt. What happened next would expose a secret so disturbing that even seasoned attorneys sat frozen in silence. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now, let me take you back to where this case truly began. My name is Judge Judith Harper. For years, I served in a busy county courthouse in the United States where emotions often ran higher than facts. Experience teaches a judge to listen not only to words, but to pauses, glances, and the things people desperately try to hide. Believe me when I tell you this. Deception has a rhythm of its own. The case appeared ordinary at first. The plaintiff was a woman named Karen Whitmore, 42 years old, polished, well-spoken. The kind of person who entered a room expecting it to rearrange itself around her. She had filed a lawsuit against a local property management company, claiming discrimination, financial damages, and judicial misconduct in previous proceedings. That last accusation caught my attention. Judges do not fear criticism. We expect it. But accusations of systemic corruption carry serious weight. Karen did not merely claim she had been treated unfairly. She insisted that court officials, attorneys, and even prior judges had conspired against her. In my years on the bench, I learned that truly wronged people often seek justice. But occasionally, there are individuals who seek something else entirely, control over the narrative. Karen represented herself. That alone is not unusual. Many citizens choose self-representation. Yet from the moment she entered my courtroom, something unsettled me. She never looked nervous. She never looked uncertain. Instead, she smiled. Not the smile of someone seeking justice, the smile of someone who believed she had already won. I still remember how the courtroom felt that morning. The quiet rustling of papers, the faint hum of fluorescent lights overhead. Jurors taking their seats, spectators whispering softly in the gallery, and there she sat, perfect posture, expensive suit, hands folded calmly. Across from her sat the defense attorney, Daniel Reeves, representing Hawthorne Property Group. He looked prepared, but there was tension in his face I could not immediately explain. Then Karen stood. Without permission, she turned toward the gallery and raised her voice. "This court is corrupt," she declared, "and I intend to expose every single one of you." The room froze. Even now, I can still hear the silence that followed. Years on the bench teach you to recognize outrage, fear, grief, and manipulation. But what I saw in that moment was different. It was confidence, dangerous confidence. As I instructed her to address the court properly, she glanced toward the defense table. Not with anger, but with something far more unsettling, satisfaction. That was the first moment I realized this case was not what it seemed. What I did not know then was that hidden inside a stack of digital evidence sat a collection of emails so explosive, they would bring her entire story crashing down before our eyes. And when those emails finally appeared on the courtroom screen, even I struggled to remain composed. When people imagine courtrooms, they picture dramatic objections and shocking confessions. But the truth is often quieter. The most revealing moments usually happen in silence, when someone believes no one is truly watching. I was watching Karen Whitmore from the very beginning. The hearing resumed after her outburst, and as I looked across the courtroom, I noticed something I have learned never to ignore. Everyone else appeared unsettled, except Karen herself. She looked comfortable, too comfortable. In my experience, innocent people facing serious litigation carry uncertainty. They may feel angry or frustrated, but they rarely carry themselves with absolute certainty. Certainty without evidence is often a dangerous thing. Karen began presenting her case. She claimed that Hawthorne Property Group had unlawfully evicted her from an upscale apartment complex in downtown Chicago. According to her testimony, management had targeted her after she repeatedly reported safety violations. On the surface, it sounded plausible. The jury listened carefully. So did I. She spoke with precision, dates, times, names, financial losses, emotional distress. She described sleepless nights, anxiety, and damage to her professional reputation. The courtroom sympathized with her. Even I initially believed portions of her story. That is something many people misunderstand about judges. We do not enter court assuming anyone is lying. We listen. We observe. We wait for facts to speak louder than emotion. Then I noticed the first crack. Daniel Reeves rose for a limited cross-examination regarding preliminary evidence. He was calm. Almost unusually calm. That intrigued me. Attorneys facing strong plaintiffs often show signs of concern, but Mr. Reeves carried himself differently. Not confident exactly, prepared as though he were waiting for a clock to strike a certain hour. "Miss Whitmore," he asked, "is it your testimony that every prior ruling against you resulted from judicial corruption?" Karen smiled. "Absolutely. No hesitation, no uncertainty." The jurors exchanged glances. "You see, broad accusations often create a psychological problem in court. The larger the conspiracy someone alleges, the harder it becomes to sustain under scrutiny, because conspiracies require participants. Participants leave traces. And traces leave evidence," Karen continued. She claimed court staff ignored her filings. She claimed opposing counsel manipulated records. She even suggested that judges had intentionally protected wealthy corporations. The gallery began whispering. I immediately restored order, but inside I felt a growing unease, not because of what she was saying, because of how she was saying it. She never once expressed disappointment, only superiority. That distinction matters. Real victims often seek accountability. Manipulators seek validation. Then there was the property manager, Emily Dawson, 34 years old, no disciplinary history. 7 years with Hawthorne Property Group. She sat quietly behind the defense table, visibly nervous. Throughout the proceedings, Emily occasionally wiped away tears. Karen never looked at her, not once. Years on the bench have taught me that eye contact reveals more than testimony. Guilty people avoid it for one reason. Manipulative people avoid it for another. They fear recognizing humanity in the person they have harmed. Then came a detail that changed everything. The defense submitted a routine request to introduce digital communications during later proceedings. Routine. Ordinary. Unremarkable. At least that is how it appeared. Karen's expression changed for the first time all day, just slightly. Most people would have missed it. I did not. Her fingers tightened, her breathing shifted, and for the first time since entering my courtroom, she stopped smiling. That was when I knew there was something hidden beneath this case. Something much larger than an apartment dispute, because experienced judges learn one simple truth. People rarely fear accusations, they fear evidence. And somewhere inside those digital records was information Karen desperately hoped would never see the light of day. What none of us realized was that a single email, buried among hundreds of messages, was about to expose a scheme that would leave the entire courtroom speechless. The third day of trial is when the atmosphere in my courtroom changed, not dramatically. Not all at once. It shifted the way weather changes before a storm, quietly, almost invisibly, until suddenly everyone realizes the air feels different. By then, the jury had heard hours of testimony. Karen Whitmore had painted herself as the victim of a powerful corporation. She described retaliation, harassment, and what she repeatedly called institutional corruption. The phrase became her favorite weapon, and that concerned me. You see, in court, words have weight. When someone repeatedly uses emotionally charged language, it can shape perception before facts are fully examined. Skilled litigants understand this. Manipulative litigants depend on it. Karen was intelligent. Exceptionally intelligent. That made her dangerous. I watched jurors carefully as she testified. Some leaned forward with sympathy. Others appeared skeptical. A courtroom is not merely a place of law. It is a place of human psychology. Every gesture matters. Every pause matters. Every inconsistency matters. Then Emily Dawson took the stand. I still remember how she walked to the witness box, slowly, nervously. Her hands trembled as she raised her right hand and swore to tell the truth. She looked exhausted. Not angry, not defensive. Exhausted. There is a difference. Emily testified that Karen had lived at Hawthorne Property Group's building for nearly 3 years. During that time, there had been dozens of complaints, not complaints filed by Karen, complaints filed about her noise disturbances. Verbal confrontations, threatening emails to staff, repeated attempts to pressure employees into granting special treatment. As Emily spoke, Karen sat perfectly still. Too still in my years on the bench. I have learned that emotional restraint can be as revealing as emotional outbursts. Some people control themselves not because they are calm, but because they are calculating. Then came the incident report. The defense displayed records showing that multiple employees had documented unusual interactions with Karen over the previous year. One employee claimed Karen demanded rent reductions while hinting that she had friends in local government. Another reported that Karen repeatedly suggested lawsuits unless certain demands were met. The jury listened carefully. Karen smiled again. I had seen it before, not in innocent parties. In people who believe they are smarter than everyone in the room, Daniel Reeves approached the witness stand. His tone remained measured, professional, almost deceptively gentle. Miss Dawson, he asked, did Ms. Whitmore ever request preferential treatment? Emily swallowed hard. Then she answered, several times. The courtroom grew quiet. Can you explain? Emily hesitated. And I noticed something important. She looked afraid. Not of the courtroom, not of the process. Afraid of Karen. That is a distinction judges never ignore. Fear leaves fingerprints on behavior. Emily took a deep breath. She told us that legal problems could disappear if we cooperated. A murmur spread through the gallery. I immediately called for order. Karen shook her head dramatically. That's a lie, she said. Her voice was sharp now, controlled, but cracking. The prosecutor and me from years long past recognized what I was seeing. Pressure. Pressure changes people. It reveals the fractures beneath carefully built masks. Then Daniel Reeves asked a question that seemed oddly specific. At the time, even I did not fully understand why. Mrs. Dawson, he said, did there come a point when communication moved primarily to email? Emily nodded. Yes. Approximately how many emails are involved? She looked toward the defense table. Over 300. 300. The number hung in the air like thunder before lightning. I looked toward Karen. For the first time since this trial began, her confidence flickered. Only for a second, but judges survive by noticing seconds. Because sometimes a single second reveals more truth than hours of testimony, and what I did not yet know was this. Hidden inside those emails was not merely evidence of misconduct. It was evidence of bribery, evidence so direct, so undeniable, that before this trial ended, the woman accusing the court of corruption would face accusations far more serious than the ones she had made against us. By the fourth day of trial, the atmosphere inside my courtroom had become unlike anything I had experienced in years. Courtrooms are built on routine, order, procedure, predictability. But this case had begun to resist all three. When I entered that morning, I immediately sensed it. Jurors whispered less. Attorneys reviewed documents with unusual intensity. Even spectators seemed to understand they were about to witness something significant. And Karen Whitmore? She arrived later than usual. That caught my attention. Punctuality may seem trivial to most people, but judges learned that changes in behavior often signal changes in circumstances. Her appearance had changed as well. The confidence remained. But it no longer appeared effortless. There was tension beneath it, the kind that leaks through even the most carefully constructed masks. I have spent decades observing human behavior under pressure. Pressure does not create character. It reveals it. As proceedings resumed, Daniel Reeves stood and requested permission to introduce digital evidence into the record. I granted it. At the time, I expected emails about lease disputes, maintenance requests, perhaps aggressive exchanges between tenant and management. What followed was something entirely different. The courtroom lights dimmed slightly as the evidence screen activated. I still remember that sound, the soft click of the projector. Sometimes history changes with noises that small. Mr. Reeves began with harmless messages. Routine communication, repair requests, payment discussions, scheduling emails. Nothing unusual. The jury listened politely. Karen relaxed. I noticed her shoulders loosen. That detail mattered. Experienced litigators sometimes reveal more during evidence presentation than during testimony itself. Then came another email, and another. Beatals began emerging. Subtle at first. Repeated demands, threats of legal action, references to influence, statements implying connections. Years on the bench teach you something important. Manipulation rarely begins with obvious crimes. It begins with suggestion, ambiguity. Plausible deniability. The prosecutor understood this. The jury was being guided toward a larger picture. Then Daniel Reeves paused, a long pause, too deliberate to be accidental. He looked toward me. Your Honor, The defense requests permission to display Exhibit 47. Karen's attorney would have objected, but Karen represented herself. And for the first time since trial began, I saw uncertainty in her eyes. Only briefly, but it was there. I approved the exhibit. The screen changed. An email appeared. At first glance, it looked ordinary, a message sent from Karen's personal account months before the eviction proceedings. The recipient's name was partially redacted pending authentication. Then I noticed Karen's reaction. Her face lost color, not dramatically, just enough for someone like me to notice. I have seen defendants react to devastating evidence before. There is a particular expression people make when reality begins collapsing faster than they can control it. Karen wore that expression. Mr. Reeves read only a portion aloud. If certain officials receive appropriate appreciation, these matters can disappear quietly. The courtroom fell silent, domiciled silence, not the silence of confusion, the silence of recognition. Even the jury straightened in their seats. Karen immediately stood. That's out of context. Too quickly. Far too quickly. People rarely rush to explain harmless statements. That is another lesson experience teaches. I asked her to sit. She complied, but her hands trembled. The same woman who had accused the court of corruption now seemed terrified of her own words. Still, the identity of the recipient had not yet been revealed. Neither had the full chain of messages. And as I looked at the remaining evidence list before me, I realized something deeply unsettling. Exhibit 47 was not the bombshell. It was merely the beginning. Because hidden deeper in those emails was a conversation so explosive that when it finally appeared on the courtroom screen, even seasoned attorneys would stare in disbelief. And I would be forced to ask a question I never imagined speaking aloud from the bench. Mrs. Whitmore, were you attempting to bribe court officials? There are moments in a judge's career that divide time into two parts, before the revelation and after it. This case had reached that moment. Even now, years later, I can still picture the courtroom exactly as it was. The faint hum of the projector, jurors sitting perfectly still, spectators leaning forward in silence, court staff frozen at their stations. No one knew what was coming, not fully, not even me. Daniel Reeves stood at the defense table with a stack of authenticated records beside him. His demeanor had never changed throughout the trial, and in hindsight, I understand why. He had been waiting for the truth to reveal itself. Your Honor, he said, the defense requests admission of the remaining email chain following forensic verification. Forensic verification. Those two words changed everything, because this was no longer a dispute over property management. This was evidence, verified evidence. I approved the request. The screen changed. An email thread appeared before the entire courtroom. The sender. Karen Whitmore, the recipient, an intermediary consultant with prior business relationships involving local legal services. My pulse slowed. Experienced judges learn to become calmer when situations grow more serious. Emotion clouds judgment. Facts do not. The first few messages seemed vague, too vague, and that immediately concerned me, because sophisticated misconduct often hides behind careful wording. One message read, "Can we ensure the right people view this favorably?" Another, "There are benefits for cooperation." Still ambiguous, still deniable. Then came the email. The email, the one that still keeps me awake at night. Mr. Reeves enlarged it on the courtroom screen. The words appeared one line at a time. If payment is necessary to secure a favorable outcome, I am willing to discuss arrangements privately. The room went silent, completely silent. I have presided over murder trials where emotions ran high. I have seen verdicts shatter families. But I have rarely witnessed silence that deep. Even the air in the courtroom seemed to stop moving. Then I looked toward the jury. Several stared at the screen in disbelief. One juror removed her glasses. Another slowly shook his head. No one spoke. No one needed to. Karen stood so abruptly her chair nearly tipped over. That's fake. Her voice cracked for the first time, not controlled, not polished, cracked. Years on the bench teach you that truth often announces itself not through evidence alone, but through reaction. And Karen's reaction was unlike anything we had seen throughout the trial. Gone was the confidence. Gone was the smile. In its place stood panic, raw panic. The defense was not finished. That was the part none of us expected. Daniel Reeves calmly introduced metadata reports, server records, timestamps, digital authentication logs. Every email had been independently verified. Every message traced every alteration attempt documented. And then came the final blow. A forensic expert testified that after filing her lawsuit, Karen had attempted to delete portions of the email chain from her personal devices. Dumb them, not deny them, not explain them, to dumb them, that distinction matters, because innocent people preserve evidence, guilty people erase it. The gallery erupted into whispers. I immediately restored order, but even I struggled to remain emotionally detached. You see, judges are human. We do not stop being human simply because we wear robes. At that moment, I was not disturbed merely by the attempted bribery. I was disturbed by something deeper. Karen had accused an entire judicial system of corruption while secretly attempting to corrupt it herself. Projection, I had seen it before. People sometimes accuse others of the very misconduct they fear will be discovered within themselves. Then I asked the question that had become unavoidable. The question I never imagined speaking from my bench. Ems. Whitmore, were you attempting to bribe court officials? The courtroom held its breath. Karen looked directly at me, and for the first time in the entire trial, she had no answer. There is a look I have seen only a handful of times in my career. It appears in the precise moment when a person realizes that the story they created can no longer survive reality. Karen Whitmore wore that look. The courtroom remained silent after my question. Ems. Whitmore, were you attempting to bribe court officials? She stood motionless, no objection, no explanation, no accusation of corruption. Only silence, and sometimes silence speaks louder than testimony. Years on the bench have taught me that truth rarely arrives dramatically. More often, it arrives quietly. After deception has exhausted itself, Karen finally sat down, her shoulders lowered. The confidence that had filled the courtroom on the first day was gone. I looked toward the jury. They had been attentive throughout the trial, but now I saw something different in their expressions. Clarity. The kind that comes when scattered pieces suddenly form a complete picture. The defense submitted one final exhibit, an investigative timeline showing months of escalating threats, demands, and attempted influence directed toward employees of Hawthorne Property Group. The evidence revealed a pattern. When Karen failed to obtain special treatment, she escalated. When demands failed, she threatened litigation. When litigation failed, she accused the system itself. And when she believed no one would ever uncover her actions, she attempted to manipulate the very machinery of justice. That perhaps disturbed me most of all. You see, courts are not perfect. No institution created by human beings is, but the justice system survives because truth matters more than power, evidence matters more than outrage, and facts matter more than performance. Karen had wagered everything on a dangerous assumption, that if she spoke loudly enough, no one would look closely enough. She was wrong. After careful deliberation, the jury returned. I still remember the foreperson standing with the verdict form in hand. The courtroom felt impossibly still. On the claims against Hawthorne Property Group, the verdict was clear, came denied unanimously. As for the evidence relating to attempted bribery and obstruction, those matters were referred to the appropriate authorities for separate criminal review. The consequences that followed extended far beyond that courtroom. But my duty was not vengeance. A judge's duty never is. My duty was justice. I looked at Karen one final time before concluding proceedings. The same woman who had entered my courtroom accusing everyone else of corruption now sat in silence, confronted by evidence she could neither deny nor escape. I have often reflected on this case since then, not because it was the most complicated, not because it was the most sensational, but because it revealed a truth I wish more people understood. The loudest accusations are not always the most honest. Sometimes people project onto the world the very darkness they carry within themselves. And sometimes those who shout most fiercely about corruption are secretly attempting to corrupt the system themselves. As I left the bench that evening, I paused in the empty courtroom. The jurors had gone home. The attorneys had packed their files. The lights dimmed one by one, and I found myself thinking about something my mentor told me many years ago. Justice moves slowly, but truth is patient. He was right. Truth does not panic. Truth does not hide. Truth waits. And eventually, if we are willing to look closely enough, it speaks. This case reminded me of why courts exist in the first place, not to reward the loudest voice, not to protect the powerful, but to ensure that facts stand where deception falls. And after all these years on the bench, that remains the lesson that stays with me long after the gavel comes down.